take a break, you can come and get your reflection paper grading rubric things. So I'll do that then. What I'm going to do is make it all the way through the takings to PowerPoint, because we actually covered most of it. And so there's a handful of important cases, important concepts that we'll cover. So I'll do that. I'm actually going to record it. Joe Rupp's grandmother passed away, so this will be a way that he can kind of plug in. So like I mentioned, if you are going to have to be absent or whatever, you can contact me and see if there's not a way that you can be present. In other words, to avoid being absent. I can't just give you some additional work to do outside of. I mean, that doesn't really count as being present. But so anyway, so that's so I'm going to record this. So every all your commentary will be recorded. Anyway, I am doing a charitable fundraiser contest that I'm going to do on Facebook. So is anybody in here a leader of the Student Bar Foundation? Yes, no, nobody? All right, so I don't want to create controversy or conflict, but over the years, what I've discovered is the things that I offer as sort of in-kind items to bid on end up is students who don't have any money who are bidding on them, which is sort of, I think, kind of not the point, right? I mean, that y'all are funding each other's public interest work seems kind of not what the, the goal is like to get lawyers who make lots of money, who are like downtown, who come, or wherever they are, I mean, wherever in town they are, but when they come, come and, bid and so forth. And instead, if it's mostly students and professors, that doesn't seem it. So, so this year, I'm taking I will take 10 people to the Kentucky Reggae Festival, which Connor won last year at the Student Bar Foundation. And instead, and actually this picture appears here. But instead of doing it as a Student Bar Foundation thing, I am doing this on Facebook to raise money for the Louisville Olmsted Parks Conservancy, New Roots, the West Jefferson County Community Task Force, and the Kentucky Waterways Alliance. And so so whichever fundraiser raises the most money, that team of 10 students is the group that gets to go to the Reggae Festival. So that's the idea. So I currently have, so I started with the first year. So and so they have teams signed up for the Louisville Olmsted Parks Conservancy and New Roots. So I brought this today to y'all in case you want to put teams of 10 of you together. If 10 of you like each other enough to go to a Reggae Festival together with me, and you like me well enough to put up with me for the Reggae Festival, there's still the West Jefferson County Community Task Force and the Kentucky Waterways Alliance that are looking for teams to, and you don't have to do anything. You don't have to contribute money. Of course, the more that you direct your friends, family, random strangers who have money to give on Facebook to these, the more likely it is that your team is going to be the one that wins. So anyway, just a little competition to try to make our community better by supporting the good work that's done out there. So questions about any of that? All right. The other thing is for next week, we are going to have a class session that's sort of special topics or advanced topics. So if there is something that you want to see addressed next week, email me now, this evening, or tomorrow. Okay, so I got to have enough time to plan ahead, and I have some ideas in mind. But if there's something in particular that, and when we're talking about something that's kind of broad interest, so like gentrification or green gentrification, that's sort of a cutting edge advanced topic that we can talk about. Sort of what should happen at the corner of 4th and Oak. That's probably a little narrow, right? I mean, so something that we can kind of tackle, so the interrelationship of legal and planning issues. And I will pick 2 or 3 of the requests I get and work them into a class session for next week. Okay, but a fair amount of time next week will be spent meeting in your teams for the hearing. So, questions? No. All right. So let me start recording. All right. So session being recorded. Good. All right. So takings. This is the second part of takings, and as we covered last week, the basic concept is the U.S. Constitution protects private property rights from certain exercises of government authority. The Due Process Clause, which has both substantive due process concepts and procedural due process concepts, is one such protection. And of course, we saw the U.S. Supreme Court engage in due process analysis in the Euclid case assessing the constitutionality of zoning. And then also, by the way, in the Nectow case, looking at the application of the rational basis test with a fairly debatable standard as applied to a particular parcel, particular zoning, and so forth. And we've seen also some of the procedural due process issues. But what we're focused on now is the Takings Clause in the 5th Amendment to the U.S. Constitution made applicable to state and local governments through the 14th Amendment selective incorporation doctrine. Just a reminder, the Takings Clause says, nor shall private property be taken for public use without just compensation. And so the issues are private property, taking, public use, and just compensation. And the types of takings, we talked about. Well, of course, sometimes the government doesn't take property, but it acquires property voluntarily through a voluntary sale from the landowner to the government. The government also can take property by just affirmatively exercising eminent domain, choosing to take the property that the landowner does not voluntarily want to sell. I just want to be clear that in Kentucky and most states, in fact, actually I don't know of any state that's not like this, the government has to first try to engage, to reach some sort of voluntary arrangement to acquire the property before they start exercising eminent domain power. Okay, so and of course that makes sense, right? That makes sense that would be the case. Three big types of takings where the government acts in such a way that it can be considered a taking, but the government doesn't admit that it's actually taking property. One is physical or possessory taking. We covered that last week. Regulatory taking, we covered that last week, and that's actually where quite a bit of zoning and land use regulation, those issues appear. This week we're going to cover exaction takings, where the government demands that the landowner give the government or the public a property interest or money in exchange for a permit to use the land. So as part of a land use regulation, the landowner has to get a permit, and one of the conditions is that the landowner provide a property interest or some sort of money in exchange for the permit. And then the last thing is we're going to talk about judicial takings, where whether this actually is even a category or not is a little unclear. And then we're also going to talk about temporary takings and ripeness. Temporary takings aren't a different type of taking. They're actually about how, usually they're regulatory takings, but they can be other kinds. They can be physical or possessory or exactions, but they're takings that do not last indefinitely, but instead only are for a limited period of time. And then ripeness is an issue about when can the landowner bring a claim against the government. All right, so exactions. Our first test involving exactions is the Nolan Essential Nexus Test, and that's N-O-L-L-A-N, okay, N-O-L-L-A-N, and that's going to be important because the second type of exaction test is Dolan. So, you know, I have no idea if the Supreme Court was doing this on purpose, right? And you know, have Smolin and Roland and so on and so forth. Anyway, so Nolan, the test is that the exaction must bear an essential nexus to the legitimate government purpose for which the exaction is demanded. Okay, so the exaction must bear an essential nexus to the legitimate government purpose for which the exaction is demanded. So once again, when we talk about exaction, what we're saying is that a permit, a land use permit or environmental permit, is conditioned on the landowner providing either a property interest to the government or public or money to the government or public. And by the way, we'll talk about the money in just a bit, but that's sort of the idea. The case Nolan versus California Coastal Commission arises out in Ventura County, California, which is the county north of Los Angeles. And this is the house that existed prior to the Nolans seeking to tear it down and replace it with a larger house. So this is what the court refers to as a beach bungalow. Okay, so it's a small beach bungalow. And the actually, let me turn some lights up here, but not too much because I'm also going to have to draw some things on screen for you. So the idea here with this is that in California, the voters in the 1970s passed a referendum, a voter initiative, actually, I apologize, voter initiative. So voter-initiated legislation to establish the California Coastal Act and the California Coastal Commission to regulate land use within the coastal zone. So the coastal zone is the area right along the coast. And the idea here is that in California, the coast is subject to public rights and the public trust. And what was concerned is that there was a lot of private land development that was blocking public access, that was causing environmental harm to the coast, and causing harm to the public's rights and interests in the coast, so the ocean and the beach and the coastal area. And so the land use regulations in the coastal zone are what we call a regulatory overlay. So we talked a little bit about that in the very first class period, where we talked about how state and federal regulations can be overlaid on top of local regulations. So they don't displace the local regulations. But the idea is, if you need, if say for example you're the Nolans and you want to replace a little beach bungalow with a big beach home, right? Then you are probably going to have to go to the local government, Ventura County or Oxnard or wherever this happens to be, whichever jurisdiction this happens to be in. And you have to get the local approvals, but you're also going to have to go to the California Coastal Commission and get a permit from them. The California Coastal Commission has taken its mission very seriously and is a very strong land use regulatory agency in California. And they make lots and lots of decisions about permits, and they're fairly aggressive about protecting the public's interest in the coastal area. And so one of the things that the California Coastal Commission said is that when these kind of beach bungalows are replaced by these kind of large homes, okay, because this is actually the actual house that the Nolans built that replaced that, right? So the top is the old, bottom is the new. What they said is that these big, massive homes on the coast were blocking the public's visual access to the beach, okay? Public's visual access to the beach. So what do we mean by that? Well, here is Pacific Coast Highway, which is also known as PCH. Has anybody ever driven up and down PCH? Okay, a couple of you. Okay, again, I'm going to say once again, you guys need to get out. So, all right. So, and the thing is, so here's a little beach bungalow here, and here, let's assume, is a massive house. And out here is the Pacific Ocean, right? I will spare you my artwork of drawing Professor Arnold out there surfing. Okay, so but nonetheless, because it would be a stick figure, right? But anyway, so here's beaches out here and so forth, and so the idea is that as the public is driving along Pacific Coast Highway, when all these little beach bungalows where you can see past them, you can see the ocean, when they're replaced by these massive homes, the public loses sight of the ocean and therefore suddenly becomes unaware that there's an ocean out there. Okay, and it's Pacific Coast Highway, so you would hope that people living in California would be like vaguely aware there's an ocean over there. But nonetheless, okay, the Supreme Court takes this on its face value, that's indeed what they're saying that they aim to do, that the California Coastal Commission has a legitimate interest in addressing the loss of the public's visual access to the ocean by a lot of development that blocks the view from the public, from the Pacific Coast Highway. Okay? So fair enough. What went on, though, in the case, though, was that there was a beach here and a beach here, and this is the Nolan's house, and it's sort of rocky cliffy there, right? So rocky cliffy being a very technical